Hey there, this is Professor Nathanson. Another video for you. This one is going to introduce Rule 56 summary judgment, but also compare it with other dispositive motions like Rule 12 and Rule 50. So let's get to it. Rule 56 I refer to as the put up or shut up rule. All right. That means that the moving party is saying to the court that either the moving party has so much evidence that they have to win as a matter of law, or the moving party saying that the opposing party has got nothing. And more typically, summary judgment is sought in that scenario. For example, P sues D for negligence for a car accident, and after discovery, there's just no evidence that D was driving the car. So at this point, D might move for summary judgment, essentially saying to the court, the plaintiff's got nothing on me. They've had the opportunity for discovery. Now it's time for the plaintiff to put up or shut up. If the plaintiff has something that is evidence from which a jury can find that I was driving that car, then let them speak now or forever hold their peace. Put up or shut up. And, you know, after the opposing party has an opportunity to respond, if they've got nothing that's either admissible or reducible to admissible evidence, then the court very well may grant the motion and grant the summary judgment. So let's talk a little bit about first then dispositive motions, namely, how does a Rule 56 summary judgment motion differ from, say, a Rule 12b6 motion or some other motions we have yet to learn about, such as Rule 50. So give me a second. Here we go. Dispositive motions. All right. These motions are all dispositive in the sense that they dispose of one or more claims or defenses or issues in favor of the moving party, right? The main difference between these claims is what materials the court can consider, the timing of the motion, the purpose of the motion, all right? So think, for example, of a Rule 12b6 motion. All right, we've talked about that in class. Motion to dismiss for failure to state a claim. Well, there, we only look at the face of the complaint, right? Only look at the face of the complaint, and we assume all well-pleaded facts to be true. We know that from the Iqbal case. We don't go beyond the face of the complaint. The furthest we can go beyond the face of the complaint would be things that are attached to the complaint or referred to by the complaint, right? But for a 12b6 motion, we don't look at the answer, we don't look at affidavits, we don't look at evidence. We just look at the face of the complaint and any materials attached to it, say like a insurance contract, right? Or a patent, or any materials referred to it, like a trademark registration that's relied upon by the complaint. We assume all of the well-pleaded facts to be true and ask, based on those facts, do we have a plausible claim, right? Well, when can a 12b6 be moved for? Through trial, anytime through trial, but in a practical matter, usually a 12b6 motion is sought before the answer is served on the complaint. So P files a complaint, P serves the complaint on the defendant serves a Rule 12b6 pre-answer motion to dismiss for failure to state a claim. And you should know already that the purpose of a 12b6 motion is gatekeeping, preventing the court and the lawyers and everyone from having to waste time and money on claims that are legally frivolous or factually insufficient. Well, this idea of gatekeeping, all right, kind of runs through a lot of these motions, right? So let's consider other motions. Here's one we haven't talked about before, a Rule 12c motion. You've read about it in Rule 12. That's a motion for judgment on the pleadings. It's done when the pleadings are closed. So say, for example, P serves his complaint, D serves her answer, pleadings are closed. Well, now either party can move for a judgment on the pleadings, right? So for example, P sues D for negligence, and D in her answer admits to everything. I admit I was driving the car. I admit I was drunk. I admit that I ran you over. I admit that I broke your leg, blah, 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 blah. Well, if everything's been admitted, why do we need to prove all the facts that are admitted? So here, the plaintiff might move for judgment on the pleadings, right? Now, sometimes a defendant might move for judgment on the pleadings, right? So when the pleadings are closed, the judgment on the pleadings is based on just the pleadings, the complaint, the answer, and the reply, if any, right? So say, for example, plaintiff files a lawsuit for battery. The defendant answers in their complaint that, yes, I admit that I hit the plaintiff, but this happened 20 years ago. And then the court orders the plaintiff to reply. The plaintiff serves a reply. The plaintiff in the reply admits that, yes, the battery happened 20 years ago. And now the pleadings are closed. Now the defendant moves for judgment on the pleadings based on the statute of limitations defense, based on the uncontroverted admissions that even though there was a battery, it was 20 years ago and therefore barred by the statute of limitations. There you go. Well, this is a less common motion. Just like a 12b6, this can be done through trial, but usually right after the close of the pleadings. And again, the purpose is gatekeeping, right? Preventing legally frivolous or factually insufficient claims or defenses. All right? That's a 12c. Well, the main thing we're going to be talking about today is a FRCP 56 motion for summary judgment. All right? Now, this is based on a lot more than just the complaint. In fact, the complaint and answer has a lesser and sometimes no role to be played. It's usually based on discovery and disclosure materials as well as affidavits, right? An affidavit is a signed document signed under penalty of perjury. So it's kind of like taking an oath to the truth of something and affirming the truth of all the stuff in the affidavit under penalty of perjury, except instead of you saying, I swear to tell the truth and the whole truth, nothing but the truth, you're doing it basically on paper, affidavit. Well, this is going to be done typically much later in the litigation, right? Much later in the litigation. Technically, it can be filed very early in the litigation, but generally it's done much later, usually after the close of discovery, right? So the rule allows it to be done, allows the motion to be sought up to 30 days after the close of discovery. Of course, keep in mind, the Rule 16b scheduling order doesn't modify those dates, but that's the basic rule. Well, the purpose here, again, is gatekeeping. Now, think about what's happened at this point. Discoveries happen. There's been disclosure. There's been discovery. People have put forth their evidence and all of that. Not the evidence that be at trial, but the disclosure discovery gives you an idea of what might be admissible at trial. So the idea here is, do we need a trial? Right? If P sues D for running them over, and it turns out discovery shows there's just no admissible evidence that D was driving the car, then why do we need a trial to prove that D did it when discovery has shown that there is no such evidence? And that's why I call, as do others, I call summary judgment the put up or shut up rule. It's gatekeeping in the sense of avoiding the need for trial when there's not a genuine dispute regarding the facts, material to the claims or the defenses, right? It's basically asking, do we need to have a fact finder? Do we need to have a trial? Because if the facts are either missing or not contested, why do we need a trial? Instead, the judge can then just decide the case as a matter of law. And as we'll see shortly, the standard for summary judgment is there's no genuine no genuine dispute regarding material facts. So the parties aren't fighting over the facts relevant to the claims or issues. And the court can then decide who wins on that issue, on that claim, or on that defense as a matter of law. It's the put up or shut up defense. Well, again, in terms of timing, that's typically going to be after discovery and before trial. So you can see as we go like this, we're moving along through the proceeding of the trial. In a week or so, we'll get to Rule 50A and 50B. This is judgment as a matter of law, all right? This is either done during trial, all right, or after after the jury has come back with a verdict, right? So during or right after the jury verdict. So this is much later in the proceedings, but again, have this idea of partial gatekeeping, either taking issues away from a jury or flat out changing the jury verdict, right? The idea here is motion as a judgment as a matter of law, also known as directed verdict. This can be done after the non-moving party's been heard on the issue and prior to submission of the case to a jury. So like, well, what would that mean? Well, say for example, there's a trial, okay, trial for negligence for running someone over, and the plaintiff puts on their case in chief. The plaintiff puts on all of their witnesses and all their testimony, all their evidence, and the plaintiff puts on absolutely no evidence whatsoever that the defendant was driving or that the defendant was driving negligently and had breached a duty. Just no evidence from which any juror could reasonably find for the plaintiff. Well, the plaintiff puts on all their evidence, and basically their evidence is a big nothing. Okay, and the plaintiff says, I rest my case. Sits down. Now the defendant stands up and says, Your Honor, I move for a directed verdict. I move for motion for judgment as a matter of a law because no reasonable fact finder, no reasonable jury could find for the plaintiff because the plaintiff has not put forth any evidence whatsoever of breach. All right, no evidence that I was driving, no evidence that I was driving drunk or negligently in any way whatsoever, right? Well, that's a directed verdict, all right? And if the court grants it, that takes the issue away from the jury because no reasonable fact finder could find for the plaintiff here, right? That's a directed verdict. That prevents the jury from deciding. But what if the jury gets the case, the jury deliberates, the jury decides, and the jury has decided clearly in a way that makes no sense in light of the evidence? Well, then that would be a 50B renewed motion for judgment as a matter of law. We'll talk about that more later in class. The idea here is we've got a full trial record, right? All the evidence has now been presented to the jury's deliberated, and now the person who lost is moving for renewed judgment as a matter of law. That's also known as a JNOV. That's Latin. It means judgment non obstante ver edicto, which means judgment notwithstanding the verdict. All right? That's the same standard. We're going to change the jury verdict on the basis that a reasonable fact finder must have found for the moving party. So imagine this case where the plaintiff had nothing, right? Plaintiff had nothing. The case went to the jury. The jury decided, or like, let me rephrase it this way. Imagine that the plaintiff rests and says, the plaintiff rests after giving nothing to the jury, right? The defendant moves for a directed verdict. Defendant moves for a directed verdict. Say the court denies it, right? Court might deny it. They often do, hoping the jury will do the right thing. So the defendant makes a directed verdict. The defendant moves for a directed verdict. And the judge says, no, I'm going to let the jury decide. All right, now the jury comes back, and the jury, I don't know, the jury is speculating. The jury had sympathy for the plaintiff. The jury decided wrong. Well, now the defendant can renew this motion that they made earlier. They can renew their motion for a directed verdict by making a judgment notwithstanding the verdict motion. Make that Rule 50B motion. It's based on the full trial record. And now the idea is the defendant is saying, I want to change the jury verdict because the jury found for the plaintiff, even though the plaintiff had no evidence whatsoever that it was me. And the standard here is that a reasonable fact finder must find for me, the defendant, and a reasonable fact finder must find for me, the defendant, because there was no evidence whatsoever of breach, right? And here the judge should grant the motion, right? So I'm not going to talk more in this video about Rule 50. That's going to be for a separate class. But suffice it now to know that in terms of time, these motions here are early and the 50B is much later, right? And the materials court consider is expanding. So 12B6, just the complaint, right? 12C, all the pleadings after the close of the pleadings. Summary judgment, typically after discovery's been done. That's much later. And then 50A is during trial, so a partial or full trial record. And a 50B is after a full trial record and a jury verdict, right? So much later, much more to look at. The purpose goes from initial gatekeeping to taking an issue away from the jury to actually changing a jury verdict. But the same idea exists through all of these, that based on what is being considered the moving party must win, right? So that's why these are all called dispositive motions. They dispose of a claim, a defense, or an issue in favor of the moving party. Now let's spend just a minute talking about Rule 56 itself. Then I'm going to go over this kind of quiz in a separate video. What I want you to do after you watch this video is read Rule 56 very carefully. All right? Rule 56A gives the standard for a summary judgment. All right? No genuine dispute as to any material fact, and the moving party being entitled to judgment as a matter of law. Right? Subsection B is the time for filing a motion. We'll talk about that as well. The procedures, all right, we'll talk about some of this as well. You can support summary judgment by either pointing to things, stuff in the record like depositions, documents, electronically stored information, admissions, answers to interrogatories, or other materials, right? Like an admissions and an answer, you could point to that, right? Or you could support summary judgment by saying, hey, look, the other side has had an opportunity for discovery. They got nothing on this necessary element of their claim, right? Or whatever they have is not admissible, and they can't produce any admissible evidence that will let me win. Or they could combine the two of these, right? You can either put forth your own materials, that's A, or you could point out that the other side's got nothing, or you could do both, right? Use your own affidavits and say that the non-moving party has nothing. We'll talk about that more in a little bit, all right? Courts do not like summary judgment early on. So if you move for summary judgment too early, the court is usually going to either allow time for you to do discovery or get affidavits, or just kind of like hold off on deciding the motion. So an early summary judgment motion, a premature one, is not going to be liked. Okay? Let's see, what else? This talks about when the court can grant summary judgment or give people more time, right? Or a court can even, if it doesn't grant summary judgment, it could consider a particular fact undisputed, all right? So it could cherry pick particular facts to be not granted summary judgment, but to be considered undisputed. Court can grant summary judgment sua sponte. So the court can say, hey, maybe this case is ripe for summary judgment. But it's got to give, because of due process, the litigants an opportunity to consider summary judgment, right? The court can even grant summary judgment on grounds not raised by a party. But again, due process, give the parties a chance to consider the issues. Court can grant summary judgment for somebody who's not moved for summary judgment. But again, courts, because of due process, are going to typically give the parties a chance, right? Here, I've noted this, even if court doesn't grant summary judgment, it can indicate which material facts are not in genuinely dispute and treating those facts as being established, all right? And then we're also going to talk some about affidavits. If you do an affidavit in support or in opposition to summary judgment and do it in bad faith, that is sanctionable. So this is kind of like a Rule 11 rule that's relevant to summary judgment. Okay? So there's more details. We'll talk about that more in the next video, but I'm going to stop this one right now, and we're going to move on to the next video where we'll take a little bit of a deeper dive into summary judgment. Thank you.